So in this video, I have a very important update in a major case against a statewide ban on the possession of magazines that hold more than 10 rounds and also a mandatory permit. This challenge has now been argued in front of the state Supreme Court, so we need to talk about what is happening in this case and potentially what happens now going forward. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also, double check to make sure YouTube is not unsubscribed you, because they love to do that, especially on two-way channels. As I mentioned in the intro, in this video, we're going to be discussing a challenge against a state magazine ban and also a permit to purchase that they put in place for all firearms purchases. Oregon Measure 114 put in place a statewide permit to purchase and a magazine ban, and that was ruled unconstitutional and struck down in its entirety by a state court judge with a permanent injunction. Well, recently the Oregon Court of Appeals issued a unanimous order upholding the magazine ban and also the permit to purchase. That decision went against the permanent injunction and what the lower court found through a bunch of factual findings. However, like I mentioned, this case is not yet over. It was then appealed up to the Oregon State Supreme Court, and now the Oregon State Supreme Court has held oral arguments on the Measure 114, the magazine ban, and the permit to purchase, and it will now determine whether that is unconstitutional. Now, the case we're talking about in this video is called Arnold versus Kotek. This case challenges Oregon Measure 114 as a violation of the Oregon State Constitution. Oregon Measure 114 first requires that anyone purchasing a firearm must obtain a permit to purchase. And second, and one of the significant things that it also did, is it banned the sale, purchase, and transfer in possession of any magazines that hold more than 10 rounds after an effective date. In response to this measure, the Arnold versus Kotek case was filed in a state court in Oregon, and on review, Judge Robert Roscio ruled in this case that Oregon Measure 114 was invalid under the state constitution and that it must be struck down in its entirety with a permanent injunction. But of course, like I mentioned, the story does not end there. Oregon then appealed to the Oregon State Court of Appeals and then asked for the Oregon Court of Appeals to reverse that permanent injunction, which was issued by Judge Roscio against Measure 114. Now, it's important to note for the purposes of this case, since this is a state court challenge and it's using the Oregon State Constitution, it has some different requirements for the type of analysis that courts need to perform. Under the Oregon standard, essentially Oregon applies a two-phase test to when they're looking at this type of issue. Under phase one, there is a determination of whether Article 1, Section 27 of the Oregon State Constitution even applies. Under the first phase, Oregon argues essentially that Article 1, Section 27 does not apply at all, since they believe magazines are not arms and therefore do not have protections as protected arms. The plaintiffs argue in opposition that, of course, that is clearly incorrect. They claim that these are clearly arms, that they're protected as modern instruments that facilitate armed self-defense, and therefore the Oregon State Constitution applies. Now, the second phase of the test when looking at this issue is almost looking at the public's interest in balancing the claimed purpose with the potential of undue burden, which is essentially impacts on the constitutional rights to purchase and possess these arms. Of course, Oregon in this case argues that in their Measure 114, that it's in the public's best interest to stop crime and to stop the proliferation of these dangerous weapons and items. So that is one of the main things that they argue, that it's in the public's best interest to restrict these items. However, the trial court judge on review found that through expert testimony and data, these public harms and the public interest that was put forward in Measure 114 is essentially overblown, and that the measure here does not meet any of these claimed interests. This case eventually made its way to the Court of Appeals, who ruled in favor of the state of Oregon and struck down Judge Roccio's permanent injunction. They held that all of ballot Measure 114 is facially valid because the law is capable of some constitutional applications. In the opinion, the Court of Appeals stated that, from the foregoing, the question we must address in this case is whether the enacting body, here the people of Oregon, enacted a reasonable regulation governing the possession and use of constitutionally protected arms in order to promote public safety without unduly frustrating the right to armed self-defense. Now, when it came to the whole permit process, they stated that the permit to purchase program and point of transfer background check reflect a contemporary legislative response to identifiable threats to public safety and a legislative determination that the risk of death or serious bodily injury to members of the public is increased by the threat posed by untrained and dangerous persons obtaining firearms. Therefore, they upheld the permit process as constitutional under the Oregon State Constitution. Now, on review of the magazine restrictions, the court here found that we also observe that the LCM ban is a contemporary legislative response to identified public safety concerns stemming from the advancements in technology and the availability of those advancements to the public that have created observable threats to public safety. But that decision by the Court of Appeals upholding this Measure 114, the permit process, and the magazine ban is now up for review in the Oregon State Supreme Court, and the Oregon State Supreme Court has now heard oral arguments in this case. Now, during those oral arguments, the petitioners focused heavily on how the Court of Appeals applied the wrong constitutional test to both the magazine ban and the permit to purchase system. On the magazine question, their core point was that Oregon and the precedent there does not allow the state to simply label a law reasonable and be done with it just by claiming that it's reasonable. Instead, they argued that the correct inquiry is whether the law unduly frustrates the right to armed self-defense. Now, several justices on the Oregon State Supreme Court pressed that issue, questioning whether Measure 114 merely regulates the manner of use of magazines or whether it outright bans possession of commonly owned arms. Now, one of the judges on the Oregon State Supreme Court pushed the state directly on whether any logical stopping point actually exists. The court there asked whether there is any meaningful constitutional difference between 8 rounds, 10 rounds, 11 rounds, and whether the state's position effectively allows them to kind of set an arbitrary capacity floor with no kind of limiting principle at all. Can they just set it to maybe 2 rounds, 1 round? If there is no limiting principle, what is the regulation actually doing? And what is the constitutional implications of the arguments that Oregon is putting forward? Now, on the permit to purchase system, the justices raised even more kind of pointed concerns about how this is operating. Several justices questioned whether Oregon can require training or government approval before exercising a fundamental right, absent something like a genuine threat or concern of violence. In fact, one of the judges kind of analogized this whole permit process to forcing someone to take a class before exercising free speech or exercising something like self-defense. Those questions by the judges here on the Oregon State Supreme Court signal that there is real skepticism about whether the permit system actually crosses the line from regulation into something like an unconstitutional prior restraint, which is not allowed, especially when you're considering things like delays, discretionary approvals, mandatory training that can essentially prevent you from exercising your rights. However, you never really know with this court here, especially the Oregon State Supreme Court, because it's full with Democrat-appointed judges, so the cards may be stacked against us. We really don't know how this is going to play out. We can only kind of gather some information based on the questions that they asked, and it seemed like they were skeptical mainly of the permit process and also how the lower court reviewed this case. The hope is that a majority of the judges will follow the logic of the questions that they asked during the oral arguments and, show how absurd, this law really is and potentially strike it down. But at the very least, maybe remand this case back down to the Oregon State Court of Appeals and tell them to do the correct analysis in this case. But even if the Oregon Supreme Court rules in favor of Oregon Measure 114 and upholds this law, there is still an option to go to the United States Supreme Court for review. So regardless, this is good news for those in Oregon and good news in general that another major magazine and permit challenge is now moving forward. Hopefully the United States Supreme Court does not have to get involved. Hopefully the Oregon State Supreme Court does their job and strikes down this law, but that's where it's currently sitting. Oral arguments were held, and now we're waiting for that ruling from the court. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the 2 videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.